All right, so good afternoon, everyone. Thank you for joining us. First of all, a big thank you to New Lake Capital Partners for sponsoring this call. Their CEO, Anthony Coniglio, is going to co-host this call. Anthony, welcome.
Thank you, Pablo and Shane. Really excited for this discussion today.
And of course, a big welcome to Shane Pennington, partner at Porter Wright, and of course, a leading scholar on all the subject of cannabis legalization. Shane, we'll start. People have access to your bio. I think most people on the line know who you are. But just a brief reminder of your expertise on the subject of cannabis reform. And then, of course, we'll get to the subject at hand, which is really to understand the legal process of bringing the scheduling recommendation to a final ruling and implementation. But just first about yourself, Shane. Thank you very much again.
Yeah, thanks for having me. I'm happy to be here. Yeah, so my background as relevant to cannabis is, I clerked on the DC circuit, the federal appellate court that oversees most concentrates the most on administrative agency challenges in the federal court system. I also worked on another court of appeals and handled a bunch of administrative law cases before that. And then since then, worked at a big firm on more regulatory stuff in a sort of wide variety of industries for a long time before concentrating on cannabis and controlled substances beginning around 2018, and have litigated multiple cases against the DEA and have represented various cannabis industry companies and groups, scientists, veterans, on and on for the last 5 years, leading up to and sort of culminating in the place where we are today.
Thank you, Shane, for that introduction. So look, the idea here first, let's focus on the process, right? The rulemaking process, and understand the various steps on the chain to final rule implementation. And as we go step by step here, Shane, in particular, in each step, let's think about, what the White House can push or accelerate or delay, and how much control they have in those various parts of the process, right? And I'll outline the various steps here, and then, of course, you opine on all of them. First of all, the questions here are, the DEA is on a Senate proposed draft rule to the OMB. When does this draft become public, or does it become public after the OMB review is finished? How long do you think the OMB review can take? And then after that, when do we have a public comment period? Is it confirmed we will have a comment period? How long would that last? Hearings follow, or do they take place during the comment period? And then after that, we understand the DOJ has to write the final ruling to be placed in the Federal Register. Another 60 days? Do they need an administrative judge to review the final ruling before it goes into a Federal Register? And we understand that once it's in the Federal Register, it must be there for 30 days before it becomes effective, right? So, but walk us through all those steps in the process, please. Thank you, Shane.
Sure. Yeah, I mean, there's a lot there. I don't know if I'm going to be able to answer them exactly in that order, but if I miss something, you can remind me. What I'd like to do is sort of set the table by, talking about the fact that, yes, this is a complicated process, and there aren't a lot of, deadlines by statute, involved in different places. But what we do know is that the President of the United States took an unprecedented step in calling for this to be done, and calling for it to be done expeditiously on October 6th, 2022. Since then, there's absolutely no question, based on my knowledge of the history and precedent in this area, that the agencies involved have followed that instruction. I mean, we got HHS's recommendation, I think in less than 11 months, if I'm not mistaken. And that normally takes a lot longer. And not only did we get it, but it's a densely cited, thorough analysis that's 252 pages long. So I guess what I want to emphasize here is, A, this is unprecedented. It's moving at an unprecedented clip. B, it is apparent, to me, and I think to everyone watching who's been watching this carefully, that the executive branch and all the agencies involved are moving expeditiously as the president instructed, but also that they're moving deliberately, and they are dotting their I's and crossing their T's. They're not leaving anything out. They are letting the science sort of dictate this, letting the evidence go where it leads them. And right now, that we know that we've had, according to Wall Street Journal, we've had OLC weigh in. So we've had the nation's chief experts on science right, weigh in very, very quickly. We had OLC get a request and presumably conclude it very, very quickly on the major disputed legal questions. Now we have DOJ having gotten the proposed rule together. It's at the Office of Management and Budget. And now to get into the actual nitty gritty of your question, but under the executive order, my understanding is that OMB has 90 days to, as a maximum that it could take to complete its review. But having talked to former heads of OMB and having talked to, I said former heads of OMB, that's not true, former senior officials at OMB and former very senior officials at DEA and HHS, lots of people close to this. I have every confidence that OMB is going to move much faster than 90 days on this. Nobody can say anything with certainty, but that is, I'm very, very confident about that. Now, once we get past the OMB stage, yes, the proposed rule will be published in the Federal Register. And my understanding is, according to reports that I'm seeing, that I'm sure many of you have seen, the OLC opinion that preceded this, that resolves disputed legal issues relevant to the rescheduling process, is also going to be made public at that same time. Generally speaking, when you have a proposed rule in the Federal Register, that you have a 60-day comment period in DEA for these scheduling actions. And then there's an opportunity for ALJ hearings, like you said. They happen, the chance to request them, they're not automatic. Interested persons can request these ALJ hearings. And then it's up to the DEA administrator whether to grant a hearing or not. And, historically, sometimes DEA does, sometimes it doesn't. Usually it doesn't. But, I think here the thing to realize is that what makes this different is that, the agency is trying to move expeditiously, A, and B, when you have an OLC opinion that authoritatively resolves some of the key disputed legal issues in a way that DEA can't override, and you have an HHS recommendation that is so thorough and so vetted, right, that's sort of dictating scientific and medical questions in the way that it is, that at the very least requires, deference from DEA. It's hard to imagine what that ALJ hearing would be about. So I'm not saying it won't happen. My view is, though, that I doubt that there will be an ALJ hearing. And if there is, as with the rest of all this, I would imagine that the agency will schedule it and go through it in a way that to make it go, as quickly as possible. And just, I've participated in DEA ALJ hearings before, and I've watched them closely. I've studied them, and in any event, they do schedule things very quickly. Things happen quickly in those ALJ hearings, anyway. So, I don't think that that's going to delay things. Of course it could, but that's not what I'm anticipating. Once we get through the comment period, yes, the DEA will need to draft a final rule. And part of that does have, to do with the review and response to significant comments. Again, though, what makes this unusual and different than any other, scheduling process that we've ever seen in U.S. history is not only is the White House behind it, but it's all the stuff that's happened up to this point, right? Where things have been resolved in a way that seems to cabin DEA's discretion in ways that wouldn't normally be the case. And that will cut back significantly on what DEA can do and consider in responding to comments. So for example, if OLC has authoritatively resolved a certain legal issue, people can comment on it. And yes, those comments will be read. But the answer is pretty simple. This has been resolved, see the OLC opinion, right? And so once we get a final rule, which I would anticipate will happen, again, like the rest of this has, expeditiously, I would imagine that, at that point, the question will be, okay, when, do we have judicial review or no? And the period for judicial review is 30 days from the time that the final rule is published in the Federal Register. That's the same 30-day period that you have before the final rule becomes effective. So the APA requires that, rules, once they're published, that there's a 30-day delay period for them to become effective. And so I would imagine that if there's litigation, the question would be, okay, well, is there anything that could happen that could affect that effective date, right? And it is true, people have brought up, and I have confirmed this in previous publications and so forth, that yes, courts do have discretion under certain limited circumstances to exercise discretion to stay the effective date of final rules. I will tell you, though, it's not the norm. It's not, a perfunctory thing or what generally happens in most cases. I was looking back, and I'm pretty sure in my, years over a decade of practice, and then, clerking on 3 federal courts, one of which focused on administrative agency action. I'm not aware of any case I've worked on, for example, that has ever had a rule stayed pending litigation. So again, I'm not anticipating that is likely. But yeah, that is something that could, happen. So I hope that covers some of the timeline pieces.
Sure, no, it does. I mean, just to step back on a couple of things there, quick follow-ups. So first of all, in terms of the proposed draft, when does that become public? Before it goes to OMB, while the OMB has it, or only after the OMB has finished the review? Because we haven't the draft yet.
You mean the proposed rule?
Yeah.
The proposed rule usually becomes public when it's published in the Federal Register, which is once OMB has completed its review, which, again, I'm anticipating that will be happening, quickly. In fact, just to share, some of what I'm hearing from the folks that I'm talking to, which again are people close to the situation, and people, former senior level people in the executive branch and the relevant agencies. I'm hearing that we could expect this as soon as in a few days or a couple of weeks. So that's what I'm hearing. Now, that's not something that I can guarantee or that anyone knows for sure, but I think the consensus is for sure that OMB is going to move quickly.
Okay, and then another follow-up there. In terms of the OLC, do we know exactly why they became involved? What were the questions the HHS asked, and what was the response, or we still don't know? I mean, there's a lot of speculation, but do we know for sure?
No, I think that what we know is that what the Wall Street Journal reported, right? And that's what I know to be the case as well. And until we actually see what OLC says, I think the most we can say is that the reporting is that there were apparently some disputed legal issues, and the dispute was between HHS on the one hand and DEA on the other. And OLC was asked to come in and adjudicate that dispute, and apparently it has. And hopefully we will see that opinion in short order.
Understood. And then, so to be 100% clear, we would say the White House has a lot of leeway here in terms of pressing or pushing for the OMB review to be done quickly. But once it's in the Federal Register and we have the public comment period, that has to be a minimum of 60 days, or can they also accelerate that public comment period?
I think that they have discretion to accelerate it. I haven't heard that they're going to do that. I know that in some cases, that aren't, where they're doing it for emergency purposes. Sometimes there's emergency scheduling and they bypass. And there are times where I've seen 30-day periods before, but I have not heard that's going to happen. I would anticipate a 60-day period, but that's just based on my knowledge of past actions. And again, this one's unprecedented, so I can't really say for sure.
And then once those 60 days are finished, how soon does the DOJ come out with a final document?
Again, I don't think anybody has a crystal ball on that. I think that what we do know is that everything is moving expeditiously, and that they're obviously, trying to do it with all deliberate speed.
Okay. But again, I'm sorry to repeat the question here. So the draft, once the OMB is finished, it goes on the Federal Register. It has to go on the Federal Register before the public comment period begins, of course, right?
Yes.
Okay. All right. And we'll have a lot more to follow up here, of course. But Anthony, go ahead. I think
I want to jump in here, and so you did a great job laying out the process. When we get to the end, a lot of people have been speculating about the need for a Cole memo too, about the need for additional guidance to come out of the DOJ. And we certainly know that the DEA has the quote unquote final authority in terms of rescheduling, but how do you think about the need or how do you think the DEA or DOJ would think about the need for incremental commentary beyond the actual proposed rule? What do you foresee around a Cole memo too, or any other regulatory action that might be necessary?
I don't think any other regulatory action is strictly necessary. It's not required by law or anything, but I mean, I'm not aware of any. I haven't heard anything. I don't know of anything that's happening where they are planning that. I'm not saying it's not. I'm just saying, I'm not aware of it, and it's not something that's required by law.
Yeah, I think that's important because I do know a lot of people have been expecting a DOJ letter to come out, a Cole memo too, and a lot of people think that the decision coming out of the DEA will require the DOJ to say something additional. I certainly don't see anything that would require them to do it. So it's interesting.
Are you saying that it would require the AG to sign off on the proposal?
No, I've heard people talk repeatedly about the DOJ would need to provide guidance to federal authorities on how to deal with issues of difference between state and federal law as a result of this move to Schedule 3.
Yeah, look, I think guidance is generally a good thing, and it's something we all hope for in the sense of, it helps the regulated public and the agencies involved and everybody kind of know what the law is and what to expect, et cetera. So, those are all good things. I just, I don't have any information or knowledge that would say that it is necessary or that it is coming. We can hope,
Yeah.
Right.
but I don't know that.
Thank you.
But on that point, and Anthony, I'll let you carry on with the flow there, but Shane, the issue here is that there's this big contradiction or tension between state law and federal law, right? You have operators in New Mexico, right? The police and authorities taking possession of their cannabis goods, which are legal goods, right? And then, of course, I could get arrested. I could have a medical, they are not for prescriptions, right? But I could have a medical recommendation in New Jersey, have cannabis in my possession, and I could still get arrested under federal law. You would think that a Cole memo is needed if you're going to reschedule to 3, but you're saying that not necessarily.
Yeah, no, if that were necessary, it would have been necessary for decades, right? Because there's been this tension between state and federal law all along. And at one point they did issue a Cole memo, then it was repealed, and now it's followed in the breach, right? Again, we can hope for it. We hope that we get guidance that clarifies things. And moreover, we hope that things continue to move in a way that narrows this gap between state and federal law, and that we start to get more rationality as time goes on. But I don't know that any of those things are going to happen, and they're certainly not required as a matter of law, as far as I am aware.
Understood. Anthony, carry on.
Yeah. 2 other points I wanted to get to. One is around the timing, and the other one's around the comment period. So on the timing, a lot of people have looked at previous rescheduling processes and have noted that some of them are actually, took as long as 3,000 days, 4,000 days. Happy to hear you talk about this accelerated path. But when I look at some of the previous rescheduling for those particular drugs, some of them weren't even commercially available. Do you think the fact that cannabis is so widely and commercially available that adds additional impetus for the DEA to move quickly here? Certainly on a path that's much faster than what historic precedent would imply?
Yes, I think for that reason and a number of others that, what you're hitting on is how unprecedented this situation is. And I think that we're far enough along in the process now to see that things not just should or, ought to, but in fact are moving quickly. I know that we've been, those of us who have been watching this and hoping for this for so long feel like it's taking forever, right? But the fact is that HHS moved very quickly. We have a lot of work having been done in a very short period of time to get OLC, get these issues up to OLC, get them resolved, get a proposed rule to OMB. We are trucking. And I think that there's no reason to think that that's going to suddenly stop and that we're going to start slowing down. I mean, there's nobody out there who's more aware of the precedent, and like the average times that these things take and so forth. And people have asked me about that a lot. And, it's not that I'm not aware of how these things normally go in prior cases in different situations. But what I am saying is, based on what we have already seen, which we now have enough of a track record, I think, since October of 2022 to now, to see exactly how this administration and these agencies are approaching this. And we have enough stuff that's already been resolved in such a thorough and deliberative way that I just feel like the table is set for, first of all, it's clear that we're moving expeditiously. And second, I think the table is set. Enough of this hard work has already been done that I really am feeling fairly confident. And so are, again, everybody I'm talking to, that this will continue to move quickly.
That's great. That's great. Let's talk for a minute about the comment period. There are a lot of people listening and that will listen to this who are very involved in the industry. And as an example, will write to senators, will call offices in Washington expressing support for various forms of legislation. When we get to the comment period, since I know that the comment period can be elongated if you get a lot of comments and they have to read through them all, is the industry better served everybody write in a letter that says, I support what you're doing, or does that gum up the works and elongate this? So what would you say to people who are thinking, I want to support this? What would your advice be to the community around the comment period? What should they consider doing and what should they not consider doing during that comment period?
I don't think, based on the folks that I've talked to and my experience with this, I don't think that people should be concerned that if they submit comments, they're going to slow things down. I mean, I could go into a lot of detail about why, but suffice to say, these agencies are used to getting a lot of comments. They're used to wading through them. It is true that there are some times that they get a lot of comments in other situations, and it does take a long time, right? But I think you just have to keep this in perspective. We're not talking about a situation that is, people are going to raise a bunch of issues that are going to be a big shock to DEA or to anyone, who's been watching, right? Like this situation is one that is well known, it's well vetted. We already have so much of this work done that, raising and fleshing out these issues is not something that in the administrative record is not something that I think is going to slow us down. I will say that people should be thoughtful about what is it that they're putting in that administrative record? What is it? We need to read that proposed rule ourselves, right? And look at it and think about, okay, now what is going to help here? So just filing a bunch of stuff that just, rants and raves about your political views or how upset you are, while totally understandable, probably isn't going to move the needle in terms of what the DEA needs to get this across the line and make it bulletproof on judicial review.
Yeah, and I also think, would you agree that this isn't necessarily a popularity contest different than maybe trying to lobby your senator? They're already making the proposed rule, assuming that the actual details come out as we all have suspected here. It's not that everybody needs to write in and say, I support what you're doing, keep going. The comments need to be more substantive with respect to the specifics in the rulemaking process.
Yes, it's not like DEA gets a certain number of comments and then they, have to make a certain decision. That's not, or if they get this many comments that are for it and this many comments that are against it, that has any bearing on what the right answer or the answer that they're required to reach by law changes. What matters, is the standard, and that they do it in a reasoned way. And, that is about the science, the evidence, and all the things that, we've been talking about all along.
Thank you. So just staying on that timeline, I guess the big picture question is, does it make a difference how far along the process is before the election or before a new president is sworn in, right? On the assumption that candidate Trump were to win the election. So not to put words in your mouth here in terms of the process, but let's say mid-May, OMB review finished, right? 60 days for the comment period. So mid-July, late July, we're done. Let's give 30 days for the DOJ to come out with a final ruling, right? Final that goes in the Federal Register, factoring administrative judge. So we could be quite advanced here. So two questions there. One, when we talk about administrative judge that has to review the proposed ruling before the final ruling goes in the Federal Register, is that the same as the judicial review process, or that's separate? And then go on.
Let me answer that one, because that's a point of common confusion. The administrative law judge, most of the time, has no role in the scheduling process. It is a discretionary channel that the DEA administrator can sometimes grant a request for an ALJ hearing. So there's an opportunity to request ALJ hearings, and the DEA administrator can grant them. If she doesn't, then there is no ALJ involvement at all. And certainly there is no need for an ALJ to sign off on this before a final rule comes out. So that's a process that can happen, but frankly, it usually doesn't. And it's certainly not necessary to get to the final rule. And it is completely different than judicial review. Judicial review is, once you have a final rule, you have to go to court, and the party requesting a challenge to the final rule would have to show that they have Article 3 standing and so forth. And it's before it would go to a federal appellate court, either the DC Circuit or another regional circuit court of appeals. And we would be in Article 3 land at that point, completely separate from the administrative process.
Right. So look, I want to stay there, but in terms of that judicial review, right, that challenge that would happen, I think you said at the beginning that it would take 30 days, but it could drag on, right, depending on whether the judge puts a stay on it or not. Or you pretty much said, no, there's not going to be a stay, so it would be a very quick process. It gets ruled out.
Can you say that again? Sorry, it broke up.
Well, in the case of when you mentioned that judicial review process, right, you made assumption that it was unlikely that the judge would issue a stay. So the process would be completed pretty much within the 30 days after the final ruling has been published, right?
No. I am not saying that the judicial review process would be complete in 30 days. I'm saying that if there is judicial review, that the federal court can, in certain circumstances, grant a stay of the effective date of the final rule. And, my view, based on just experience, that usually doesn't happen. It can, but it usually doesn't. And I can't think of a reason how, personally, right here, off the top of my head, any reason how a party could come in and say that they could meet the standard to show that they would, be entitled to a stay of the effective date. If the effective date of the final rule is not stayed, right, then the rule becomes effective. And that means we have a Schedule 3 change at that point, regardless of the litigation. And the only way that changes is if the court at the very end of the litigation ultimately, sets aside the final rule. But in the meantime, the rule will be effective. Does that make sense?
But yes. And just to be, again, not to put words in your mouth, the way that you outline everything, it seems that by September or October, the final ruling could become effective already based on all the steps that we've discussed. Do you agree with that?
I'm sorry, I'm just having trouble hearing. It broke up in the middle of what you were saying. Can you say it one more time, please?
Yeah. Based on the way you have outlined the process and your expectations about how long each step will take, it sounds to me that you are making the assumption that the ruling become effective as early as September or October. Do you agree with that?
Well, I'm not making any particular assumptions myself about when it will become effective. I know it will become effective 30 days after it's published in the Federal Register. I've tried to explain all the reasons why I think that this is moving expeditiously, and that at every stage there's every reason to believe that it will continue to. But I'm not trying to say it's going to happen in September or something like that. I don't want to have people take me to be making a particular prediction like that, because look, that's just just listen to what I'm telling you about the steps involved. It's not that I'm saying that it's going to take forever. That's the opposite of what I'm saying. It's going to move fast. What I am saying, however, is that because of the number of steps involved, it's very difficult to get down to it's happening on this date, and if there's anything that people who have been, watching this process can tell, it's that those sorts of predictions have generally turned out to be untrue, and it's because it's very difficult to make that kind of prediction. The best that we can do is say that, we know the White House wants this done. We have every reason to believe that the agencies are moving quickly, and each step in the process should not take, if it's done quickly, any kind of, crazy long amount of time.
Right, understood. So let's make the assumption that it becomes effective by September or October. Does that make any difference in terms of if candidate Trump wins the election? I'm just trying to understand the ability of a new administration to reverse the whole thing, whether this has become effective already in September or October, or they can just wipe the whole thing off.
Right. So there are two, maybe three different aspects to that question. The first is the Congressional Review Act, which allows a new administration to kind of look back and undo some of what the old administration did. I'm not, I used to be, I have notes on it somewhere, but off the top of my head, I'm not ready to tell you all the details about the Congressional Review Act and when the timelines are, but that's out there. People can find that. I just don't have it off the top of my head. The second is, say that we have a final effective rule, right? By the time the Trump administration comes into office, and they say, gosh, we want that thing off the books. Under the Administrative Procedure Act, in order to get that done, they have to go through the process again. Okay. So, could they do that? They could try, right? But once it's already out and it's, it's final, they would have to go through a process to do that. And it starts to become very complicated because, query whether there's already a federal court reviewing it, right? And it starts to become complicated about what happens there. But suffice to say that it is certainly not automatic. It's not like President Trump can come in and issue an executive order saying, yeah, that didn't happen. Like, that's not how the world works. They have to go through the same administrative channels. Sometimes presidents come in and try to do, really extreme things. Like, I can't predict what sort of novel things a new administration might try, right? People can do crazy things, right? But I'm just telling you in general, the way that it works is once an administrative decision is made in a certain way, undoing it requires the agency to follow that same administrative process to reverse it in general.
Right.
The other way it can change is through legislation. So those are your channels. And, I don't see legislation happening, and, you guys can make up your own minds about what it would mean for a Trump administration to come in and try to reverse this after it was already done and following this whole process again, after it was just documented, papered up, went through all this and presumably got all the way through all this multi-agency review, et cetera, et cetera. I mean, I guess anything's possible, but I'm not, I would feel very good if we had a final rule going into the Trump administration.
Right. So no, that's very clear, very helpful there. Look, just to follow up here, and here we are, speculating about the way the White House would think about this politically, right? But let's say I'm a strategist there. I would say, well, let's not make the final ruling effective before the election. Let's wait until after the election, because the way we tell people, look, re-elect President Biden, and this will become effective. The problem with that scenario is that it becomes easier for President Trump in the future, if re-elected, gets to reverse the process, right? On the other hand, these strategies could say, you know what, let's play it safe in case that we don't get reelected. Let's make it effective now before the election. So, if we lose, at least this thing will go through.
Yeah, I mean, look, these are political questions that are really beyond my, I don't have any special expertise about this. I'll tell you my own view is I want this done as fast as possible and I want to get it done. But that doesn't, there are other people who are far more qualified to talk about what's best for the Biden administration.
No, I understand. But the way, and I'm sorry but just to be 100% clear, obviously, if it doesn't become effective before the election, it's a lot easier for the new administration, the Trump administration, to reverse the whole process than if it had become effective. Do you agree with that?
Yes. Once you have a final effective rule, that's when they have to go back through the process. if they're not through the process and the Trump administration comes in, I believe it would be, easier to halt that process. But I do want to say, there's a lot that's already kind of resolved in pretty authoritative ways by authoritative agencies, including OLC and HHS. So while I wouldn't be celebrating something like that if it happened, a lot of this, a lot of the toothpaste is out of the tube at this point, so I'm feeling bullish about it at this stage, which is something that, people who've been listening to me and reading what I've said for a long time will know that is something that has taken me. I've had to see evidence. I've had to see it happen. I've had to see the changes actually start to become real. And we're not all the way through yet, but gosh, we've come a long way so far.
No, that's good. So Anthony,
I'll weigh in on this for a moment. And of course, I'm no political strategist, but it would seem to me that it's unlikely, if something that's finalized, that a new administration would go against 80% of the American public. And it just doesn't seem like a big enough hill to die on politically, is my personal view. To me, the biggest risk this industry has is the proposed rule occurs, which I think we all expect to happen well before the election. But the final rule isn't done by the inauguration. And therefore, you get a new DOJ head, you get potentially a new head of the DEA, and a final rule just sits and languishes as a non-priority. And then we're kind of waiting and waiting. I'd like to think, though, that as Shane pointed out, that I'll just stay with your analogy, that the toothpaste is out of the tube at this point, and that if the DEA has made a decision, they're going to want to see through it and get it off their plate, is my view. I don't know if either of you want to comment on that before I go on to my next question.
There's every reason to believe that they want to get this done. I mean, like the OLC process was fast. DOJ confirmed they transmitted it to OMB. Everything I'm hearing is that they're trying to get it done as quickly as possible. HHS went as fast as it could. And I mean, look, you have the president of the United States for the first time in history. I mean, there's literally no other example of this directing these people to do it. So we don't have to really wonder about it.
Right.
Like at this point, I think it's clear that they are. So, that's why I feel confident about that.
Yeah. So then the next big fear that people in the industry have is legal challenges. And you wrote in the Oklahoma Law Review, along with two other authors, a great piece, and I've actually pinned it on my X page if anybody wants to go read it. I think it's a terrific piece that lays out a lot of the components. But in there, you talk about lawsuits and you talk about the deference that courts have shown for the administrative branches. I'm not describing that correctly, for the agencies within the federal government that are charged with whether it be controlling substances like the DEA, sure, or discharging their other responsibilities. I think it would be helpful if you laid out for the listeners a little bit about why you have that confidence and why, if there are these inevitable lawsuits, maybe these lawsuits will drag out over time once a final rule is done, and why you think the agency will likely prevail, and how that ties into how careful they've been here and taken the extra time up front to dot the I's and cross the T's.
Sure. So at the outset, it's important to know that the deference doctrines that you're talking about are, the main one, Chevron deference, is currently before the Supreme Court. And that there's a lot of belief that the Supreme Court at the very least is going to rein in Chevron deference. But right now it's still on the books. And, there's I think among experts, I think more believe that the Supreme Court will kind of rein it in, cut back on it some, or limit its application to some degree. But then there are ones who think that they're going to actually just get rid of it altogether. But that said, the deference that's shown to these administrative agencies actually inures to our favor in this case, for once, because this time, unlike the last times, the agencies are coming out, consistently for Schedule 3, right? HHS has, it went through this detailed analysis. It's got all, 252 pages, all the studies it cited. Then we have OLC. Then we have now the proposed rule, right, that apparently backs that up. And so all of the agencies, law enforcement, health agencies, legal experts, all are aligning around one view. And when you're a court, and again, I clerked on 3 federal courts, and so I'm speaking from, a wealth of experience. When you're a court and you're looking at, a challenge to an administrative action, courts know that HHS is a scientific and medical expert, and they know also that they are not. So there's no confusion about that when you're sitting on the DC circuit. I know that because I was there, okay? And so you generally defer to scientific and medical experts when you're a judge because you know that they know more about it than you do. And more importantly, Congress delegated authority to them and did not to you, right? And it goes the same way with law enforcement. Judges are not police officers. They are not DEA agents. That's not their job. And so they try to say what the law is, but they defer to the experts on these particular issues. And that's because Congress has given those experts that authority. And so regardless of what happens with Chevron deference, one thing that people, I think it'll stay in place to some extent. However, even if it doesn't, and you get rid of Chevron deference, the general background rule that existed before Chevron was still deference to expert agencies. It was just a different standard. And so I don't want to get into all that because it'll just bore people. But the point is, regardless of what happens, we are on such strong footing going into federal court. If we get a final rule that's backed up by this sort of administrative record and we get this across the line, we are going to be in infinitely better shape than we were in all those past times where, the agencies came out against us. When you're going against the federal government in federal court, you're fighting uphill, with one arm tied behind your back. When you are defending what the federal government did, you are in a much stronger place.
Very good. I think that's what we all want to hear.
Okay, thank you, Anthony. So, Shane, in the same article in the OLR, you talked about the good probability that rescheduling would go through, but you said that in the case of this scheduling, the path was much narrower. Can you explain that, please, for the audience here?
Descheduling? Yeah, sure. Descheduling, so first of all, that's just not on the table, right? Like the chances of that happening at this stage in this administrative process seem, extremely remote. But I will go over, why that is. In short, it's because, there are so many reasons, but the very critical one is that DEA has repeatedly said that, if a substance were to be descheduled, it would fall out of DEA's jurisdiction entirely. And once that happens, DEA could no longer carry out its statutory duty to ensure, that a substance is scheduled in the way best, most appropriate to ensure U.S. treaty compliance. And so there's a lot of flexibility, I believe, and as we argued, to put a substance in different schedules and still meet that, treaty provision requirement. But if you take it off the schedules altogether, it's kind of hard for DEA to do anything. It doesn't have any control anymore to be able to do anything with the substance. That's one reason. Another reason is it's one thing to say that cannabis has a lower abuse potential than PCP, which is a Schedule II substance, right? Or fentanyl, which is a Schedule II substance. But it's a very different thing. And I'm not saying it's impossible. Please don't mishear me. I'm not saying it's impossible. I'm saying it is a much harder argument to make to say that it has, less abuse potential than, Schedule V substances like prescription cough syrup and so forth, right? And in general, the harder you make it to show something, the harder it is to show. And the easier it is to get that overturned in court, the less likely that, the agency will feel like it has the evidence before it necessary to make such a decision. So, yeah. And then the more likely it is that a court will be like, wait a second, I'm not sure that this doesn't seem to fit. And so Schedule III, feels like we're in our sort of power band, right? But if you were to try to deschedule, there are a number of reasons to wonder if that could survive the process.
Understood. Now I want to move the discussion to what the proposed ruling is going to look like. We don't know the details yet. but the assumption is that you move to 3, 280E goes away, there's more research, but that cannabis remains federally illegal, right? And we keep this tension, if you want, or contradiction between state law and federal law. But the question for you here, the way I understand the CSA, it's a federal construct, right? There's no one CSA for Oklahoma and one for Texas. So how is the DEA and the DOJ going to deal with that, in your opinion?
They're going to deal with it exactly. I mean, nothing's going to change. Like they're going to deal with it exactly as they have, right? Like, it's not like cannabis is becoming more illegal. You know, they're loosening the restrictions. So the idea that they're going to loosen the restrictions and then suddenly ramp up enforcement, to me, not only does it make no sense as a matter of just sort of common sense, but it also doesn't make any sense because they would need resources, right, to start cracking down on, you know, cannabis enforcement. And unlike legislation that comes with appropriations, right, this administrative process isn't giving anybody any money or giving DEA more employees or anything like that. There's just absolutely no reason to suspect that this is some sort of like deep head fake where they're telling us that they're loosening the restrictions and then actually they intend to ramp up enforcement. And to be clear, like, let's say that they had that appetite to ramp up enforcement, right? Like, let's pretend for a second that they did, even though there's no evidence that that's true. But like, let's say that they did. If they did, they could do it today while cannabis is in Schedule 1. So there's absolutely no reason for them to move it to Schedule 3 to do that. And if they ever change their minds and want to do it, they could do it in Schedule 1. So it just doesn't make any sense that this is actually a move to try to increase, you know, federal interference with the cannabis industry.
And what about bifurcation? I mean, right now, obviously, medical cannabis and recreational cannabis and the CSA, they are both 1. Now we move to 3. The way you're describing it, there's no change in that sense either. The rules for either one don't change.
Well, there's a huge change there, and that is that the federal government now apparently, at least in a draft form, DEA, then we also have, you know, HHS, you know, agrees, like, uniformly across the board for the first time in history that cannabis does in fact have a currently accepted medical use and treatment in the United States. That is huge, 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 and historic. It doesn't mean that cannabis is approved for interstate marketing as a drug under the Federal Food, Drug, and Cosmetic Act. But as far as, you mentioned the word bifurcation, there is this thing called bifurcated scheduling. This is going to get technical, everybody. So, you know, if this isn't your thing, like, get your pillow ready for just a second. I'll get through it as fast as I can. But a lot of people ask me about this, and it's technical, and I'm just going to walk through it real quick. There is such a thing called bifurcated scheduling. What happens? Let's take an example. GHB, the date rape drug. That was a street drug, right? But it got FDA approved eventually for some indication. I forget which one, but there's a prescription, a pharmaceutical version of GHB out there. And the pharmaceutical companies that sell that have DEA licenses to sell that drug and to distribute it and so forth. But the street drug GHB, which is a, you know, different formulation of the same compound, right? That is still illegal and in Schedule 1. When FDA approved the pharmaceutical version of GHB, they moved that formulation out of Schedule 1. And I forget where it is now. Is it 3 or 2? But in any event, it's in one of those 2 schedules, right? And that has created bifurcated schedule. You have the active ingredient, the street drug GHB, in Schedule 1. You have the pharmaceutical compound that is, you know, been sponsored through the FDA process, et cetera, is now in a different schedule, 2 or 3. I forget, you know, which one it is. And this has happened with other things too, like even cannabis type stuff. You have, you know, synthetic THC is in Schedule 1. It's listed separately than marijuana, but dronabinol, Marinol, Sativex, those have been moved to 2, 3 different schedules depending on what formulation it is. And so this happens sometimes where a pharmaceutical company gets something through the FDA process, and that compound that is the proprietary compound of that pharmaceutical company is moved out of Schedule 1 and placed into a different schedule, while the rest, every other formulation of that drug, remains in Schedule 1. To be clear, that is not on the table here at all, because the cannabis has not been FDA approved. So the basis for that sort of bifurcation simply doesn't exist here. So I've heard a lot of people talk about this idea that there will be medical cannabis placed in one schedule, and then the rest of it will be in a different schedule. And like that, there's no evidence that that's happening. There's no historical basis for that to happen. And the examples of bifurcated scheduling, and there are many, I went through several of them here, but none of them justify doing that with cannabis at this point. If you read what the Attorney General said, if you read what HHS wrote, all of that points uniformly in one direction, that the administration is looking at cannabis as a whole, and it is transferring all of it out of Schedule 1, not just some of it. So I hope that addresses the question.
Yes, it does. Thank you. Look, and then this is going to be a question more of your opinion, more necessarily than fact, but for the U.S. exchanges, NASDAQ, NYSE, or even for banks to become more proactive in the way they deal with the industry, do you think that this schedule change would be enough? I mean, the product is still federally illegal, but could a NASDAQ or a bank feel more emboldened to operate with the industry? And I know that, it's your opinion more than a fact here, but any thoughts on that?
Sure. So there's nothing that like automatically requires them to change their position, right away. Like it's not like that. It's not an on-off switch like it is with 280E, because there's a statute that says, 280E applies to Schedule 1 and 2 substances, and therefore if you aren't one, then it doesn't apply. It's not like that with the examples that you listed with banking and so forth. That doesn't mean that they couldn't change their position, and certainly there would be some rational basis for them taking a look at it, right? But I don't. It's not automatic is the most that I can say.
Right. And look, this is and Anthony, just chip in here, but we want to jump around a little bit here. But when I try to think about the David Boies lawsuit, right, by people in the industry, how is the DOJ on the one hand be pushing for rescheduling and allowing the state programs to remain viable while still keeping it federally legal, and then make arguments against what David Boies is saying? And any quick thoughts on that?
The two are just completely separate. I mean, I know a lot of people don't think that they are. I don't think that what I'm saying is crazy, but in fact, because like you said, Schedule 3 doesn't suddenly, make cannabis, federally legal or make the state programs, federally legal. There's nothing necessarily contradictory about the two. And I mean, beyond that, for a number of reasons that I can't get into, I really can't comment further on the Boies lawsuit. But I will just say that I see the two as, very, very distinct. And I don't think that there is any necessary inconsistency in the positions that DOJ is taking.
Understood. Right.
Yeah, let's actually play off that for a moment, though. And if you go back to Justice Thomas's dissent,
standing akimbo. Yeah, standing akimbo.
Yeah, right. And so he kind of invited this challenge, or almost invited a case to get to the Supreme Court. What do you make of that? I know, whether it's the Boies lawsuit or whether it's some of these circuit courts where you have gun rights as a particular issue relative to an individual's ability to access state legal cannabis. And what do you make of the different paths to get to the Supreme Court?
I'm not sure exactly what you're asking me. I mean, I guess what I would say about Justice Thomas's position in standing akimbo, I mean, I think he made a really, really powerful, compelling point. And of course, I think it stems from his experience with the Gonzalez v. Rage case, right?
Yep.
Everybody can go read that if you want. And it's, it makes sense that Justice Thomas would say that. And I think his position is eminently reasonable. And you're right that it invited a lawsuit. And, I think that the Boies lawsuit was obviously in part a response to that. As far as, the other issues that you raised, I guess that the best that I can do here, what I think is worth really emphasizing is that if there's one thing that we, kind of have learned, as we've watched this process unfold, and just from my experience, litigation can get stuff done when nothing else does, right? So if you look at, Matt Zorn getting the HHS recommendation released, that was through a lawsuit that he filed pro se, and, litigated himself, for free. And if you look at other situations, he and I collaborated on a suit that, ended the Magnum Opus and got research opened up by allowing growers to get licenses to grow cannabis for research. He and I also collaborated on another one that recently got DEA reversed in a slightly different context in a rescheduling proceeding. And so litigation does work and it does move the ball. And I don't think that I think I'm really happy to see people taking notice of that because, at a time when, and look, I'm not poo-pooing any other channel, but it's just, you got to know you got a lawyer. You're talking to a lawyer, and I can't help but be, I need to be a cheerleader for what we can do because I really believe that we have a lot of talented lawyers in this space, and we've done a lot of good, and I think we can do a lot more than we currently are with litigation.
Yeah, no, I totally agree. Because the legislative branch certainly has been slow. The administrative branch certainly seems to be doing their part. But I do think that I agree with you. I do think, and the reason I was highlighting some of these circuit court decisions is because it appears that we're getting dissension amongst different circuit courts around the constitutional nature of restricting access to firearms under Amendment 2. And so if you've got one federal circuit saying it's unconstitutional, the other federal circuit saying it is, it seems like we have a Supreme Court for this very reason to arbitrate between dissenting opinions in different circuit courts. And so I think it'll take years to ultimately get there, but it would seem like that type of gun case. And I'm surprised the gun lobby hasn't taken up more, especially given so many veterans that have access or do access medical marijuana and how it can impact their Second Amendment rights. But it seems like yet another avenue for this topic around marijuana to make its way to the Supreme Court.
Yeah, 100%. I have a notebook I keep that is a list of all of my zany ideas and plans and things. And one that I go back to often is I've imagined a case where, there's a veteran, or even imagine a veteran's spouse where the veteran died in combat. Now the spouse, dealing with the trauma and all of the mental health and physical health ramifications of having lost their warrior partner, is left with, a house full of kids and a mortgage and so forth, and dealing with it all, goes to their doctor to explain, what they're dealing with, gets a medical marijuana recommendation. And then without their warrior spouse, at home to protect the family, right? Because they died in combat, they, want to purchase a firearm to exercise their Second Amendment right to defend themselves. And they go to the, academy or the, whatever it is, the Walmart, and they're told, no, you're a drug abuser, and under federal law, we can't do that. And, I just imagine that case, in my mind, making its way up through the court till you get to the, ultimately to the Supreme Court, and query how the current Supreme Court would react, or how anyone, frankly, would react to such a case.
Yeah, I bet you that case does exist out there, what you painted. If I could pivot a little bit, so we get through rescheduling. We're now on Schedule 3.
Yep.
I've heard some people say, well, maybe the cannabis companies can go get registered and become quote unquote legal because we know there are pharmaceutical companies. Can you talk a little bit about, I know not a lot of people, in fact, I'm not fully aware of all of the protocols and all of the requirements you'd have to go through to get licensed by the FDA. So talk about that. Is that a viable strategy for people in the sector?
So on the one hand, it is possible, and it's possible because folks have already done it. They've done it in Schedule 1. They've gotten registered with DEA to, research Schedule 1 drugs. I've helped clients get registered to grow cannabis, bulk grow it with a DEA license. It is possible. It has been done. And they've even taken cannabis compounds and put them through the FDA gauntlet, paid the $1 billion price tag to do the clinical trials and bring drugs to market. That's Jazz Pharmaceuticals and Epidiolex. I think many of us are familiar with that. And so it's not something that can't be done. It has been done. There's no question that it can be done, right? But it doesn't. It's very, very costly to go through that FDA process. And bringing a drug to market as a pharmaceutical drug, look, I think it has happened already, and I think it will continue to happen in the future. But the bottom line is that rescheduling isn't making clinical trials cheaper. Okay, it's still a very, very expensive process, and there are reasons why pharmaceutical companies aren't, chomping at the bit. I mean, even in Canada, once they changed their laws up there, it's not like pharma moved in and just bought the entire industry up or something, or just suddenly swooped in. Like, that's not how it works. The reasons that the pharmaceutical companies aren't jumping in, are separate from, they have nothing to do with the Schedule 1 status. And likewise, just because it moves to Schedule 3 doesn't mean that all of what, doctors are doing or dispensaries are doing is something that the federal government is fine with. Certainly not in interstate commerce, right? It will still be illegal to market even medical cannabis in interstate commerce, because medical cannabis will remain an unapproved drug under the Food, Drug, and Cosmetic Act. But the important thing to know is that that's how it currently is, right? So that's not more restrictive than it is now. That's the same. And so I don't think people should expect those things to change. I think that what they should expect to change is 280E, and the cash that will come from that will be a boon for the industry. It means removing criminal penalties associated with violations of 280E. So this idea that there are no criminal justice implications of this is also it's a myth. There's a lot more to do in that way, but it is definitely something, right? To remove that criminal penalty. And so that's what I think is the big change, the thing that's gonna really have an impact.
But just on that point, I mean, when people, some of the advocates, calling for a broader reform, when they make the argument, then the only thing that's really going to change is the fact that 280E goes away. What would you say to them?
Well, it's simply not. I mean, like, first of all, let's just take on this criticism just for a second, because a lot of people have been very, very critical of President Biden, right? And I'm not, I don't work for President Biden, and I'm not getting paid by the Biden administration or anything like that. And people have criticized that he hasn't, he's pardoned certain folks who have committed certain federal crimes, but he hasn't, there's still a lot of people in prison. But what people don't recognize and don't often talk about is the people who are in prison for cannabis violations, the vast majority of them are in prison for violating state laws, okay? There's nothing President Biden can do other than what he did, which was encourage the state governors to change those laws, right? And that doesn't mean that there's nothing more for us to do on criminal justice reform. That just means that, we all have to work together. And I think fighting what is obviously a historic victory to have the federal government recognize out in the open, not just one agency, right? But basically now all the agencies involved, recognizing for the first time that cannabis does have a currently accepted medical use, and that its abuse potential it's not as absurd as to say that it's, somehow as high as PCP and fentanyl. That is a massive step forward, right? And I think that what people are really concerned about is that there might be, that people will get this change and then they won't do any additional work on the criminal justice piece. But what I can tell you is, I was working on these issues before this process kicked off for years on, research, criminal justice, all of this, and I'm eager to continue the work. And then one more thing I want to say about this. It's not just that it changes the criminal penalties associated with 280E. It does other things as well. So, for example, a lot of what goes into criminal charging, right? When you look at how somebody actually ends up, getting arrested, charged, convicted for a cannabis-related violation, it has to do with discretionary decisions of police officers, prosecutors, and judges. Okay, they all have to make decisions to make those things happen. And in general, all things being equal, if you study it, you'll find that, again, all things being equal, Schedule 3 drugs are treated more strictly than Schedule 1 drugs are treated more strictly than Schedule 3 drugs when it comes to those discretionary decisions. And so it's not crazy to think, in fact, I think it's reasonable to say that we can expect that on the whole, cannabis-related violations across the board will likely be treated, less harshly as a result of this. And people just don't seem to recognize that. They seem to assume that, and the other thing that people seem to think is, like, if we descheduled, right, you hear this all the time, that would end the federal prohibition and there wouldn't be any criminal laws associated with cannabis. That's not true. That's not true. it would still be a violation of the Federal Food, Drug, and Cosmetic Act to market cannabis as a drug in interstate commerce. The Federal Food, Drug, and Cosmetic Act can be enforced criminally. There's a lot more to it than people say. And also, descheduling would not change a thing about prohibitionist states. In fact, generally speaking, when there's a huge dramatic change in federal law, sometimes you see like a counter punch come from the state level among the folks who disagree with that. So if immigration restrictions are loosened at the federal level, sometimes you see border states ratchet theirs up, right? And so you could see the same thing happen here. The point isn't to say that we shouldn't be working on criminal justice. We should, absolutely. And I'm here to help. I've helped pro bono on these things. I'm eager to continue doing so. I'm just saying that descheduling isn't a utopia. And what the president has done is extraordinarily meaningful and has historic ramifications. And I think that we should celebrate those and continue the hard work.
Yes, of course, agreed. Look, I know we're over the hour here. Two more questions from my side, Shane. And again, we all appreciate very much your time here. So in terms of a 280E going away, any thoughts on whether this can be done in a retroactive way, right? It becomes effective September. Can the company say, well, don't charge me 280E from 1st of April, 2024, or even, going back further in time, making the argument that it was never fair to be, it should have never been there to start with. Any thoughts on that?
So applying the change retroactively on 280E?
Mm-hmm.
Yeah. So there is a standard, but there is a standard for when laws apply retroactively or when relief applies retroactively. I haven't studied it deeply, and frankly, this is something that I know there are tax experts out there, which I am not a tax expert. So for those reasons, I hesitate to weigh in on something like that, mainly because I know there are people out there who probably have that answer, and I haven't looked at it closely. So I'm sorry to not have that one ready to go.
No, thank you. Look, and one last one. This is more a comment, but I'd love to hear your opinion on it, and it's not about legal expertise. So there's this, if you want, this tension in terms of how the industry plays out in the future, right? We have these very license restricted systems, state-by-state rules that allow for attractive profitability and economics for the operators. And then you have states that are more competitive, like California or Michigan, or you look at Canada, very competitive, right? And economics are very different. So someone could make the argument that the Trump administration, assuming that they don't reverse the process and that the final ruling goes in and is not reversed, that the Trump administration thinking about states' rights and leaving this as is would be great for the MSOs, as opposed to maybe, a second Biden term that would have the Schumer bill, CAOA, and other more proactive bills in terms of 3 tiers, separating distributors, producers, and retailers, higher taxes, federal oversight, that, a Trump administration could be great for the industry in that sense. I know it's a political opinion, but I'd love to hear your thoughts on that briefly, Shane.
My reaction is that all I can say is that I know that as a movement and as an industry, we need to have contingency plans for everything that could possibly happen. And I'm certainly thinking about, okay, what is the best, how do we move forward from here, regardless of what happens? But the fact is that I am way out of my pay grade when we start talking about, what this political change would mean versus that one. I am much more in my area of strength when we're talking about the more boring stuff about the law and the process. So I don't have a strong opinion other than the experts out there who know, how to navigate some of those questions. We certainly need them at the table. We can't wait until something like that happens to have a plan in place. We have to be prepared now for anything. And because, you have to, every strategic decision that you make depends on all the strategic decisions you might make in different contingencies, right? This is beyond chess. You know what I mean? This is extremely complex stuff. And I think it's important as you talk to people and hear people talking, to know that, like, if you hear somebody who seems to know everything and thinks they know everything, that's probably somebody that you ought to, take what they say with a grain of salt. What I'm telling you is I don't know a lot of these questions that you're asking me, but I do know some of them, and I've tried to answer the ones that I can.
No, fair. Anthony, before we finish, any closing questions on your side? And thank you again.
No closing questions.
Thank you.
Yeah, no closing questions, but I did want to go back to a point and weigh in when you were talking about uplisting. I couldn't get off of mute soon enough. I'll give my input on that and my thoughts. I think for those that are listening that are investors, I think it would be very dangerous to make decisions around investing in any companies based on uplisting, because when you think about the issues that exchanges or banks have, it's around aiding and abetting, it's around money laundering. There's significant risk for them. And what we heard here, what we all know is that this rescheduling does not rectify those legal issues. So certainly they can have a different perspective and they can choose to make the decision. But the expectation that Schedule 3 occurs and everybody will automatically be able to uplist, our company is in the same at NewLake, our company's in the same position. I think that would be somewhat misguided without some further evidence from the exchanges or without other reform, perhaps a safe banking act that has a safe harbor. So I just wanted to add that. And then I wanted to say, Shane, thank you, not just for taking your time to be with us here today, but I see you weighing in a lot around the industry, providing insight and perspectives to folks that hit you up, and you're spending a lot of time educating the industry, and just want to thank you for that. I think it is of great use to make sure that people are really educated on these complex issues. So appreciate you leaning in on that.
Yeah, thanks for saying that. And thank you so much for having me and for everybody tuning in to listen.
Shane, I'm going to ask one last one here, if you don't mind. Okay, so
Sure.
In terms of the way that you explain everything here, I'm just trying to understand what would be new once the draft ruling comes out. I mean, the OMB is done and then that's published. It sounds all the details here we're quite clear about. I mean, there's no bifurcation, there's no federal legalization. We're moving from 1 to 3. I mean, what are we expecting that would be new information from the draft itself once it becomes public?
Well, I mean, it's very difficult to answer that just in a vacuum, because the DEA could say many things to get from point A, where it is now, to point B of we're recommending Schedule 3. But what it says really matters, because we're trying to get not just a proposed rule, but to a final rule and to a point where, this survives judicial review down the line. And to do that, we need to make sure that the administrative record fully supports every premise, legal and factual, scientific and medical, that is in that proposal, and that becomes that final rule. And the other thing is, it's going to change how the opponents of all of this respond. The fact that things are going really well now is only going to motivate them. And so we need to see, what that rule says, so that we can anticipate the counter arguments and build the administrative record that's going to get us, across the finish line. And so it's beyond that, without seeing the details, unfortunately, it's difficult for me to comment. And just to give you an example, like I wrote a lot, for people who are interested, I wrote a lot about this before the HHS recommendation came out. I and a group of very talented attorneys and doctors worked with a group called the Coalition for Cannabis Scheduling Reform. We wrote a white paper before the HHS recommendation came out, explaining how we thought that this could get done, the legal ways, the science ways, all of that, right? And then what HHS came out with, it didn't cut and paste what we said. I mean, I think that what we said largely tracks what ended up happening. But the point is that HHS went way further and had way more to say, and they looked at way more data. And so I think you could kind of look at it like that, right? Like, we kind of know what it's going to say, and we kind of know what's coming, but the details really matter, And if you look at, for example, after the HHS recommendation came out, Matt Zorn and I each wrote analyses of it and what its implications were. And the detail, if you read that, I just assure you that the details matter, right? And so that I expect to be the same once we see the proposed rule. And so I'm really eager to get my hands on it so that we can get to work.
And one quick one, just from someone that emailed me on the question. So once the OMB is done, pretty much as soon as that's done, the proposed draft becomes public, right? The two happen. We get to, for investors, we get the two pieces of information at once. One, OMB is done. Two, here's the proposed draft. We get both pieces of information will come at the same time. Is that true?
Yes, that's true.
Okay. All right, Shane, if you want to make any closing remarks here, again, I echo what Anthony said. Of course, we thank you for your time. We thank you for your thought leadership on the subject. And of course, I look forward to more and more discussions on the subject matter in the months ahead. But again, a big thank you to you. And of course, thanks to everyone for joining us today. But Shane, any closing remarks?
No, I'm just very grateful for the time and for everybody tuning in. And you guys asked a lot of questions and a lot of really good ones. So I hope this was helpful for folks.
I believe it was. And again, a big thank you to our Newley Capital Partners for sponsoring the call. And thank you, Anthony Paniglio, for co-hosting. Have a good day, everyone. Thank you.
Thanks.